I'm excited to let you know that on September 4th, 2020, AILA, along with its co-counsel from the Innovation Law Lab, the Justice Action Center, and Mayor Brown, successfully won relief for this year's class of DV 2020 selectees. Judge Mehta, a district court judge in the District of Columbia, issued an injunction that will pave the way for this year's diversity visa class to have their visas issued on or before September 30th. And if it's not done, there's a chance that the deadline will be extended. And we have to go back to the judge on September 25th and provide the judge with further information for all those now seeking to get their visas issued. Now, let me give you an overview of our case to begin with, because we sought relief for many groups that are subject to what I describe as Banzilla, which is Presidential Proclamations 10014 and 10052, that greatly restricts the immigration and entry of immigrants and non-immigrant workers, those who are seeking an H visa or an L visa or an H-2B visa or a J visa. Now, those non-immigrant visas were not granted relief by Judge Mehta, and the immigrant visa class, other than those seeking diversity visas, also did not get the benefit of Judge Mehta's order. That's unfortunate. We have options available to appeal, and there's a competing case in the Northern District of California that will have a hearing on September 11th that may, if successful, benefit those non-immigrant workers who desperately need relief. Here's what we need you to do if you're a diversity visa applicant. It's contact the consulate. Make sure you have all your documents ready to go. Maintain contact with your consulate directly. For those who are already been qualified or who already had an interview, or perhaps an interview that was canceled, I need you to go and contact that consulate immediately, and do not stop until you get an interview. Okay? You also want to make sure your medicals are up to date, or that you're able to get your medical exam quickly if the consulate decides to schedule you for an interview. When you request an interview, for consulates who are not presumed routine services, that you qualify, if you're a DV 2020 selectee, for an emergency interview or a mission critical interview. That is specifically within the judge's order, and it's specifically within your right to go get an interview. Our fabulously talented co-counsel at the Justice Action Center and the Innovation Law Lab have put together a form for DV 2020 selectees to fill out, so that we can learn about how the State Department is implementing the judge's order to issue visas immediately. The form does not mean we represent you, but it will help all those who've benefited and who have not benefited from the judge's order by providing us with information that we can bring to the judge's attention, so that if an extension of the visa deadline past September 30th, 2020 is necessary, we have the information and we have the evidence for the judge to issue that ruling. Now, you've heard me say issue visas, but not entry. And I want to make that point clear. The judge's order in his ruling was that the president may suspend the entry, including the entry of DV selectees who are now issued visas. But the State Department cannot restrict or use that proclamation to not or adopt a no visa policy. And that's the distinction that you need to really focus on, so that these diversity visa selectees may have their visas issued and deserve to have those visas issued. But that does not mean that they have the ability to enter the United States. We know this is a once in a million chance for those who won the lottery this year and greatly benefit from having the chance to immigrate to the United States. While we wish you could join us in the United States soon, we do know we've obtained the ability for you to have your visas issued.